Lawyers of Reddit, what's the most ridiculous argument you've heard in court? As a corporate lawyer, the most ridiculous argument I come across almost monthly is as follows. Fortune 500 company signs a garbage contract and is going to lose a lot of money due to the plain language of that contract. Fortune 500 company argues unconscionability, specifically that said company was not sophisticated enough to read the contract and no reasonable person would ever agree to the term or terms in dispute. In sum, multi-billion-dollar firms claiming they're incapable of reading contracts. Law student, former professor's story. Defendant busted for possession of narcotics. They were in the pocket of his leather jacket. He argues the search was illegal because with his buttery smooth leather jacket, there's no way the officer would have felt the drugs in his pocket during a pat down, so he shouldn't have reached in the pocket to find the drugs in the first place. Judge asks if the jacket is the one he was currently wearing in court. It was. Judge asks to feel this jacket and the pockets. Defendant hands it to the bailiff. Judge finds more drugs in the pocket. Needless to say, it didn't go well for him. I was a juror, but this was a heck of a defense. Defendant ran through a red light and crossed against traffic in front of an officer. She was over twice the limit. It wasn't her fault. She had a cut on her arm that her dog licked. The yeast from the dog's saliva entered her bloodstream and converted her blood sugar into alcohol. An opposing attorney the other day said I should not cross-examine his witness at a preliminary hearing because it would only hone the witness's testifying skills to be cross-examined at trial. I laughed out loud. Some douche in my law school class warned me that his debating skills had been honed in the most unforgiving of internet forums. He meant it unironically. A lady has an injury comp case. It's for her upper back and of course complex regional pain syndrome. She decides she needs the insurance company to pay for a special mattress for her, like a $6,000 memory foam, with heat and massage and 1,000 other features. And not just a twin. She needs a California king because of course her layabout unemployed boyfriend needs to sleep there too. We spend months litigating this dang thing. Finally, she buys it herself and my client agrees to give her $1,500 just to be done with it. The judge takes myself and opposing counsel aside and says he's gonna motherfuck us if we ever say the word mattress in his court again after wasting all this time. It was that ridiculous. Not 3 months go by and the case comes on for another hearing. After exhausting all the chiropractic care allowed under the law, her doctor was seeking a variance to get some additional chiropractic. We get to court and I'm arguing it should be denied, etc. Judge turns to her and says, "Mom, why do you feel you need more chiropractic care?" She pauses for a minute then says, "I'm having a lot of trouble sleeping on my mattress. I think I saw smoke coming out of his ears." In family court hearing a motion for entry of a restraining order for an abusive husband. Husband's lawyer argues that in a marriage, there is implied consent for a certain amount of abuse violence. To have and to stranglehold. Old lady slipped and fell on an icy driveway which was not salted or maintained, so she wanted to sue for damages. After hearing the story, turns out the lady fell on her own driveway which she did not salt maintain. She was wanting to sue herself. Had a pro se litigant argue that she didn't owe the credit card company because Jesus. The basic argument was that debt is a sin, or maybe not paying the debt was a sin, and Jesus died for all of our sins. Therefore Jesus died to pay off her debt. Brilliant. I was in the public gallery for this while studying law. I was not the lawyer. Leeds Crown Court back in the early 90s. 75-year foreign. Yes, this is important. Man was facing a preliminary hearing relating to charges that he had intimately touched a 13-year relative. His barrister made a successful plea for bail based upon this man being an established pillar of the immigrant community, and the judge asked the old man if he had anything to say before he was bailed until the next hearing in a month. He made 2 comments. 1. She was wearing very, very tight shorts and I should not be held responsible because no real man could resist something like that. The judge reminded this was a preliminary hearing not a trial so he should wait until the trial to argue his case, especially statements that are far from exculpatory and are better suited to mitigation. 2. I cannot reappear in a month because I am flying back to my home country tomorrow and will not be coming back. The barrister appeared to be just as surprised as the rest of us. The judge ordered the defendant's passport seized and he was remanded in custody until his trial. Recovering small business BK attorney here. Was in bankruptcy court on a motion of my own. When a very young attorney gets up to argue his position, his request was denied in pre-hearing disposition. Young attorney: yeah, Your Honor, I believe your reading of the 3 cases you have cited is incorrect. Bankruptcy court judge: BKJ, you think that, do you? Yeah, yes, Your Honor. I don't think the bankruptcy appellate panel believed these cases would be used in this fashion, and I think you are misreading the author's scope. BKJ: okay, tell me, as those are BAP opinions, who wrote those opinions? Yeah, I'm not sure, Your Honor, I didn't check. BKJ: in the future you may want to check those sorts of things. All 3 cases were authored by the judge you just told didn't understand his own writing. Yeah, blank stare. BKJ: Fassapam Jesus, son, I wrote those opinions. Yeah, oh, well I still think they're wrong. BKJ: request denied. Get the heck out of my courtroom. It was, quite possibly, the most awkward type of walk of shame I've ever seen as he gathered his things and left. Not a lawyer, but I was in traffic court and a cab driver had got a ticket for running a red. He argued that it was really difficult to see because the sun was rising. Morning, right where the light was. He was traveling west. That sounds like a Phoenix Wright attorney case. Lawyer here. During an order of protection hearing, the 6 feet 3 inches muscular tattooed idiot told the judge that my 5 feet 1 inches female client deserved the black eye he gave her because she wouldn't stop running her mouth. He actually expected the judge to be sympathetic or something. The second he admitted to hitting her, the judge cut him off and said order of protection granted. Next case. Not in court but a conversation in my office. It doesn't matter if you were sober or not. You jumped out of a 3rd story window with a beer bottle and threw it at a cop. The jury is going to think you were drunk. Also, I think you were drunk. Hands down the most ridiculous argument I've ever heard was a constitutionalist. Pro se defendant trying to explain why the court lacked jurisdiction over him. I was prepared for the standard arguments about freemen on the land, non-corporate natural person, admiralty court, etc. But this one was different. This particular defendant was part of a Jehovah's Witness compound and happened to be Marshallese American. That is, he was black. After the court patiently explained to him that it has jurisdiction over all persons in the county, the defendant promptly piped up that, under the Dred Scott decision, he wasn't a person and the court had no jurisdiction. Not so much ridiculous as ghastly, but a man accused of having non-consensual intercourse with his own daughter saying he couldn't have done so because he had a 9-inch dong, and it would have caused her damage, and that the physical signs of intimate activity that she did exhibit were because she'd been screwing the family dog. I don't do criminal law anymore. That was enough for me. I'd left the firm by the time it actually got to trial, but was kept in the loop about the case by friends still there. He was found guilty and went off to prison. This came in a deposition, but it's still one of my funniest stories from this old job. I worked part-time as a paralegal when I was in college. We had this massive case with a lot of people involved that had spun out into a bunch of little side cases. In one of those side cases, this guy was claiming our client had left him threatening voicemails related to the main case, and him and his wife sued for loss of consortium. Loss of consortium, and I swear to you this is a real thing, basically means something happened that is stopping a married couple from sleeping together, and they want to sue you over it. The guy was claiming that he was so scared from these voicemails that he couldn't sleep with his wife anymore. Deposition time rolls around, and I'm sitting in the other room, but it's a small office and I can hear everything. My boss starts asking the wife how we're supposed to know that it was our client's fault they stopped sleeping together. Maybe she's just not as attracted to him anymore. Maybe he's not attracted to her. Maybe they didn't have that much of an intimate life to begin with, etc. So this woman starts yelling I love fricking and banging her fists on the table. Her lawyers try to calm her down and tell her to stop talking, but she keeps on shouting I love fricking. We used to frick too. 3 times a day. We'd be thrown out of hotels because of the noise we'd make and to the protestation of everyone in the room, her counsel and ours. She proceeded to describe their intimate history in graphic detail, all of which was recorded in the deposition and filed with the court. Former assistant state attorney prosecutor here. This defendant is called up for arraignment and the judge is telling him that he's been charged with theft for stealing a roll of scratch-off tickets from a gas station. The judge informs the defendant that since the value of the tickets was over $300, therefore it's a felony rather than a misdemeanor. The defendant says to the judge, "But Your Honor, to be fair, the tickets were all losers," implying it's not theft at all. I was amazed at the ingeniousness yet futility of the argument. Traffic court. Speeding ticket. Your Honor, I didn't speed, and I can prove it with logic. Judge, a KII. Lady, I drive a Prius. Judge, lady, that proves I'm responsible, specifically in the realm of cars, so I obviously wouldn't speed. She had to pay the ticket. She should have argued the Prius lacks enough power to speed, even if one wanted to. I'm not a lawyer nor could I talk at the time. During a custody battle between my grandparents and my mom and dad who were addicts, the judge asks why my parents should have custody. Well, we are his parents. The judge says, well, you guys have substance abuse issues. No, we don't. So you're not using anything? No, we're both clean. When is the last time you've used? A few days ago and we're done now. My grandparents won that day in court. This story has been told to me a few times by my grandfather. Actual lawyer. What I dub the surprise party defense. In a hearing for an order of protection in which ex-wife is trying to get an order of protection against ex-husband who had been stalking her. They have a high school age child together. Ex-husband tries to argue against the order of protection by saying they may need to be able to communicate about the child. The judge points out that they can communicate through the child, and also that other family members have been put in place by the juvenile court to be intermediaries, pickup, drop off, etc. Then ex-husband has a brilliant light bulb idea. Judge, what if I need to throw my son a surprise party, and I need to keep it secret from everyone, but his mom still needs to know so she doesn't throw a party the same day? In other words, while I admit have been stalking my ex-wife and that there are grounds to grant an order of protection, you should not grant that order just in case I need to throw a surprise party one day. What made it was how clever he thought the argument was. Thus was born the surprise party defense. This never made it to court. I asked my divorce lawyer what was the worst thing a client had asked him to argue. I was expecting a I want the salad spinner sort of story. He had a client, a professor in his 70s who was divorcing from his wife, also a professor in her 70s. They were both Jewish. His wife had a tattoo on her arm. It was a number, put there by the Nazis when they put her in a concentration camp in World War II as a child. Husband was born in the US, was not German. The German government was in the process of settling a case with the survivors. She had some amount of money, a six-figure sum, due to her tattoo. The husband wanted his lawyer to argue that he should get half the settlement money. Lawyer told him that there was a special circle in heck for lawyers who ask for stuff like that and that he was not planning on ending up there. Wasn't the other lawyer, but his client, took the stand in a retail theft trial, claimed he didn't steal a couple salmon fillets on purpose. He was just so flustered by a phone conversation with his girlfriend that he accidentally slipped them into the pockets of his jacket. In a part of the store the loss prevention officer called Shoplifter Alley because it's a blind spot for the cameras, and walked out without realizing it. It's not like it was a candy bar or something small. It was 2 salmon fillets. I asked him, have you ever done that before him? Number me, have you ever seen anyone, anywhere, ever put fish like that in their pocket in your entire life? Him. Number. Mercifully, the jury did not buy his ludicrous story and found him guilty. I am a lawyer. Had a female inmate claim she was touched inappropriately by one of the guards. One of her most damning pieces of testimony was testifying to this large vertical scar he had on his chest from a heart operation. She continued to say that she remembered this huge scar from when he touched her. The guard got on the stand, took his shirt off, and he had a tiny horizontal scar up on his shoulder. Case over. He had apparently told her one time that he had surgery, and she assumed it would have left his giant scar and used that to make up her story. There was a case in Georgia a while back where a kid claimed a teacher touched her. During the trial, somehow testimony involving something the kid said about the shape her breast came up. Turned out the teacher had had a double mastectomy. The kid was describing breasts that didn't exist. Also a lawyer. Had opposing counsel try to argue that because a landlady had written on her eviction notice "It has been a pleasure getting to know you but please leave," but had testified they were awful tenants that she hated, that she was dishonest and nothing she said could be trusted. Not a lawyer, but when my mom was killed by a drunk driver, we were filing a wrongful death suit, and the lawyer for the defense used my mom's cancer to say that she was going to die anyway, so a wrongful death dispensation was not owed. Not a lawyer, but I do have a story for this. This happened while I was working as a medical assistant. One of our diabetic patients got a speeding ticket while his blood glucose was low, and he seemed to be under the impression that this would be an ironclad excuse to get him out of it. So he calls our office one day, and I answer. PT will be the patient. Me. Dr. X's office. Threadquifel speaking. How may I help you? PT. Hello. I need the doctor to write a letter for me. Me. I can definitely help with that. What is the letter for? PT. I got a speeding ticket last weekend, and I'm going to contest it. I need a letter from the doctor stating that I have diabetes and that it impairs my ability to drive. So it wasn't my fault I was speeding. Me. Let me run through this with you, just so I'm clear what you're asking for. PT. Okay. Me. You want a letter stating you have diabetes? PT. Yes. Me. And you wanted to say your diabetes impairs your ability to drive? PT. Yes. Me. And you believe telling the judge that your diabetes impairs your ability to drive will get him to throw out the ticket? PT. Yes. Me. I don't think that's a good idea, sir. PT. What? Why? Me. Even if they agree with your argument and toss out a ticket, which I doubt they will, if you tell them that you have a medical condition that impairs your driving ability, I'm pretty sure they'll take your license away. PT. No. See, I'm only impaired when my blood sugar is low. Me. Right, but this would go on for a few minutes before I told him I'd ask the doctor and see what he thinks. And surprisingly the doctor agreed with me, said he would lose his license if he did that. So we didn't write the letter, but he still brought this argument to traffic court. The patient is now driven to his appointments by his family members. I wasn't a lawyer, but a law clerk working with the prosecutor's office. This guy was caught on the highest quality security cam video I've ever seen, stabbing a store clerk like 15 times. She survived, and then was tackled a block away from the scene not 5 minutes later by a man who had seen him flee and followed him 25 feet from the knife and the jacket he'd been wearing that was covered in blood with a receipt with his name on it in the pocket. It was the literal definition of a slam dunk case. The guy chose to proceed to trial without his lawyer instead of having the case postponed after his attorney's house was broken into and all his files were stolen. This guy's main argument was that it wasn't him because in the statement of probable cause written by the officers after the incident they misspelled his highly unique last name by adding a T in the middle. For example, Johnson became Johnston. He spelled his name out at every opportunity with much emphasis. He also argued it couldn't be him because the man on the video tied a t-shirt around his head so that the distinctive tattoos there would be hidden. But he would never cover over his tattoos like that because he was proud of them and they represented his heritage as a Korean man. The jury took less than a half hour to return a guilty verdict. You have been visited by the Be Humble, Be Stay Humble and Believe in Yourself. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check out another video, or don't. Either way, have a great day you magnificent people.